I don't think there's any one way for law firms to grow. I think that one of the most important factors will be creating efficiencies within the business model, and particularly in two areas. The first is efficiencies in the human capital element, and the second is efficiencies in technology. Nothing is more wasteful of resources for a law firm than losing its best people. And I think that law firms will have to focus on creating a culture with which their employees and partners can identify and want to be part of. In terms of investment in technology, I think that will mean both capital investment in the hardware and software, but also recruitment of different types of people. There will be no hiding place for inefficiencies in law firms in the future. I'm not surprised that the ambitions of law firms 18 months ago were to invest in mergers, but I'm equally not surprised that many of those mergers have not come about. And I think the reason for that is that mergers are so very difficult to achieve. First of all, one has to have the right mix of practice areas that the firm looking to merge is seeking to acquire, the right geographical footprint, if that's going to be an international merger, and the rock on which many merger discussions founder is that elusive one of culture. How things are done around here, the approach to management, the approach to how the partners remunerate themselves, their approach to their colleagues, to client service. All of those things are quite intangible, but they're extremely important. So difficulty in achieving mergers, and also law firms are starting to think about alternative strategies which are less difficult to achieve, but perhaps can attain many of the objectives that were set for a merger. For instance, team moves have become very popular. I think we will see more mergers, particularly in the mid-market, and perhaps more international mergers than national ones. But I think that we will see fewer than previously. The merger is not dead, but I think it's very elusive. I think there are a lot of legal pitfalls arising out of the obligations that partners owe to their firms. And these obligations arise not only out of the contract between the partner and his firm, the membership agreement in an LLP or the partnership agreement in a general partnership, but also out of the general law. And it always amazes me how blissfully unaware partners are of their obligations to their firms. There is an obligation on a partner to keep his or her firm's confidential information, precisely that, confidential. And one often comes across an interview situation where a recruiting firm is asking very intrusive questions about the confidential business of the firm from which the candidate is coming. And the partner, him or herself, is often very willing to disclose information of a very sensitive nature, who the clients are, how much they have been billed over the last 2 or 3 years, who are the best performers in the team. And I think that's a real problem. Increasingly also, many firms are protecting themselves very effectively against team moves, making the departure quite uncomfortable with long notice periods, restrictive covenants that protect the client base following the move, garden leave during the notice period to separate a partner from his client base. And that can end up in the recruiting firm having to pay serious amounts of money to buy out those obligations. Team moves are not easy to pull off because of all these legal pitfalls, but with a certain amount of discipline, they can be achieved very successfully.